May I please the Lord?
Yes, yes.
My Lord, I beg to mention item number 6, my Lord. Hearing matter. It may be taken up on next week, my Lord. Today I have some personal problem, my Lord. Next week, any day. Much.
May I please your lordship? I have a mention for listing. Lordship, it's an urgent matter of custodial death and the matter may be listed on 30 January. Lordship,
When did you file?
22, 2022.
22nd, not on 30th January. We'll have it on first.
Obliged, lordship.
May I please, Lordship, I would to mention that item number 3, urgent for the day.
Item number 3, are you sure?
Sure.
On behalf of state, are
J.
you,
Ahmed.
on whose behalf you are making prayer?
Huh?
For
J.
whom?
Ahmed. J. Ahmed. I'm appearing on behalf of J. Ahmed.
He is appearing for whom?
Petitioner.
Wait for your turn.
Huh?
Wait for your turn.
May it please the lordship. Lordship, I want to withdraw this matter as there is inherent mistake in my petition, lordship. Moreover, the annexure were not properly filed. I want to withdraw this matter with the liberty to file afresh.
Order message, Veteran and Council appearing for the petitioner. And Mr. A. Payang, Standing Council from Department Assam for the response number 2. Seven and 8. Mr. AIL, Standing Council, Election Commission of India for the response number 3. And Mr. P. Sharma, Additional Senior Government Advocate Assam for the responding numbers 5 and 6. On instruction of the petitioner, Mrs. Patel, Learned Council appearing. Learned Council. Praise for withdrawal of this writ petition. Seeking liberty to file efforts as an this for the right. Prayer allowed. Petition stands dismissed. On bail. John. We that also FP case number 3 of the 2018. That was called for by earlier order dated 10/11/2023. Be returned to the office of the learned member of Foreigners Tribunal, Imahasa. Portrait.
Much.
A copy of this order.
Malady, do you moderate for any past malady?
Not in this case. Interim was not passed.
Yeah.
Last day, you lost.
Or Mr. Ardubil and council appearing for the petition. Pursuant to the order of the court passed earlier on 19/12/2023. After serving of notice to the respondent number, the opposite party number 7. Lord Chief Judicial Magistrate Dibrugarh, by her communication dated 20/12/2023, apprised the registry of this court about the service of notice of this application. You see, opposite party.
সেভেনের কারণে নতুন কে বের করছে
নতুন
নতুন কে বের
Are you appearing for respondent number 7?
Yes, Your Lordship. We are the newly engaged counsel, Lordship. We have received the instruction from the client yesterday, but we have not received the brief. So I pray for,
Did you file any occult number?
we'll file in during the course of the day.
What's your good name?
A Kashyap,
Full name?
Arya Jyoti Kashyap. The
Mr.
lead counsel is Mr. Joyraj Bora. I'm appearing on his behalf.
Mr. Arjya Jyoti Kashyap. Learned counsel. Along with Joyraj Bora.
Joyraj Bora.
Have appeared in this matter. For দুইজনের communication number. On instruction of the opposite party number 7. And submitted that they are yet to receive the brief. It is also stated the Learned Counsel that's in charge for the respondent number 7. Ekash. That during the course of the day, necessary Okalatnama oblique power shall be filed by them for the respondent number 7. List on 8th of February.
My lord, I have one prayer, my lord. In the main case, my lord, these authorities have filed their affidavit, we will file our reply. The CWC, my lord, who has lodged the FIR in that case, my lord, in spite of direction by your lordships, they have not filed their affidavit.
Doesn't matter. We'll do the
Let-
needful
let's-
in the next date.
My lord may then indicate, my lord, that they have
First
forfeited
we'll-
their.
First
my
we'll
lord.
consider your application,
My lord.
then we'll consider.
Notice, Lordship, item number 3, adjourn for the day.
Take your seat. What's your good name? Oh, you are appearing.
My lord, next week may taken.
3830. Under prayer of Mr. J. Ahmed, learned counsel for the petitioner. Mr. Matter is adjourned for the day and list on 30/01/2000.
Lord. It please your lordship. I'm hearing on behalf of my senior Mr. I. Your lordship. The petitioner lordship, the name of her grandparents, it appears in the voters list of 1966. That is at page 15, annexure A, lordship. Her grandparents' name is Jinnat Ali and Dubjan Nessa. Thereafter, lordship, in the voters list of 1970, which is at page 18, lordship, her grandparents' name again appear as Jinnat Ali and Dubjan Nessa. Thereafter, lordship, in the voter list of 1979, again her grandparents' name appear, Jinnat Ali, Dubjan Nessa, page 21, lordship. These three voter lists are of the village Pakhiura, lordship. Thereafter, their grandparents shifted from Pakhiura to Darogar Alga village. Therefore, the name of the petitioner's parents, Soiful Ali and Johra Khatul, that appears in the voters list of 1985, annexure D, page 24, your lordship. Thereafter, lordship, again her parents' name appears in the voters list of 1997, that is at page 26, lordship, annexure E.
The petitioner lordship, she was born in the year 1980 in village Darogar Alga. Thereafter, her name appears for the first time in the voters list of 2005 lordship, along with her husband. That is at page 28 lordship, NHRF. Petitioner's name Kamala Khatun and husband Jilal Sheikh. Voters list of village Buduchor. Thereafter, in the year 2016, petitioner and her husband's name again appear in the voters list of 2016 of village Buduchor. That is at page 31 lordship. Serial number 62, Kamala Khatun. Serial number 61, her husband, Jilal Sheikh. The proceeding was initiated in the year 2007 lordship. The petitioner, she received the notice for the first time in the year 2017. She duly contested, adduced her evidence. Her uncle also adduced her evidence, her own uncle. Thereafter, the Gao Panchayat secretary also, he adduced his evidence. The learned tribunal has the impugned opinion, which is at page 53 lordship, and on 4/9/2018. Only proof of establishing her link was the Gaon Panchayat secretary certificate, Lordship. That was produced, but due to the age discrepancy in the certificate, that was not taken into consideration.
Please take your seat. Yes, kindly read the written statement at page 32. To start from page para 3.
That the respondent is a bona fide citizen of India by birth and was born and brought up at village Darogar Alga, NC, PS Pancharatna, District Golpar, Assam in the year 1980 approximately. That Saiful Ali and Johura Khatun are the parents of the opposite party and the opposite party is an illiterate person. That Jinnat Ali and Dudjan Nessa were grandparents of the opposite party. That the respondent's parents have 8 children, namely Kabuja Khatun, Saifal Ali, Jasmal Ali, Hasmat Ali, Saeb Ali, Fazal Ali, Naib Ali, and Hakim Ali. That there are 6 brothers and sisters of the respondent, namely Sabuja Khatun, Komela Khatun, Johirul Islam, Habijul Ali, Shahidul Islam, and Zakir Hussain. That the name of the respondent's grandparents have been recorded in the voters list of 1966, part number 174, white serial number so-and-so as Jannat Ali, son of Khalil, aged about 45 years, and Dudjan Nessa, wife of Jannat, aged about 35 years, respectively, against house number 49 in the village Pakhiura, PS Golpara, district Golpara, Assam, under 45 Golpara East, LSE. The name of the respondent's grandparents have been recorded in the voters list of 1970 by part number 174, white serial number 140 and 141 as Jannat Ali, son of Khalil, aged about 49 years, and Dudjan Nessa, wife of Jannat, aged about 39 years, respectively, against house number 49 in the village Pakhiura, CS Golpara, district Golpara, Assam, under 45 Golpara East, LSE. That the name of the respondent's grandparents have been recorded in the voters list of 1979 part number 136, white serial number 133 and 134 as Jannat Ali, son of Khalil Sheikh, aged about 56 years, and Dudjan Nessa, wife of Jannat Ali, aged about 46 years, respectively, in his house number 27 in the village Pakhiura, PS Golpara, district Golpara, Assam, under 37 Golpara East, LSC. That the respondent has got married with one Jilal Sheikh, son of Motibur Rahman of village Buduchor, Sundarpur, PS Motia, district Golpara, Assam, under 37 Golpara East, LSC, and shifted to her matrimonial home. That the respondent has 4 children, namely Jelekha Khatun, Abdul Ilyas, Mojida Khatun, and Iqbal Hussain. That the respondent has casted her vote for the first time in the year 1997 along with her husband. That from the facts and circumstances mentioned above, it is seen that the respondent never entered India illegally after 1971, but this proceeding has been brought falsely against her only for harassment, and so it needs to be dismissed. On the other hand, it needs to be declared that the respondent is not illegal immigrant, rather she is bona fide citizen of India by birth.
Now, read page 49.
I know the OP. Her name is Komela Khatun.
No, not 49. This is, okay. Read this, page. Forty-six.
I used to go LP school of Darogar Alga NC for few days. I have born and brought up at Darogar Alga NC. Soiful Ali and Johura Khatun, my parents. Jinnat Ali and Dudjan Nessa were my grandparents. I got married with Zilal Sheikh of Sundarpur. At that time, I was 18 or 19 years old. About 20 years ago, my marriage solemnized. I have 2 sons and 2 daughters. Abdul Ilyas, Ekbor Ali, Julekha Khatun, Mojida Khatun. My father possessed landed property at Darogar Alga. We are 4 brothers and 2 sisters. Jahirul Islam, Habijul Ali, Saidul Hussain, Jakir, Sobia, myself. I have casted my vote for the first time at my matrimonial house. Last election, I casted my vote.
Okay. Now you read page 49. Who is he?
Lordship, he is the uncle,
Name?
Hasmat Ali, Muhammad Hasmat Ali. I know the OP. Her name is Komela Khatun. She is my own niece. She is an illiterate lady. OP is now 37 years old. Now she is residing at village Sundarpur, Buduhar. She took birth at village Darogar Alga and also brought up at Darogar Alga. Her marriage took place with Jalal Sheikh of Sundarpur, Buduchar. Her marriage took place about 22 years ago. At the time of marriage, she was 15 years old. OP have 2 sons and 2 daughters, namely, sons are Abdul Ilyas and Iqbal Ali, and daughters are Jelekha and Majida Khatun. Jinnat Ali and Dudjan Nessa were her grandparents. Saiful Ali and Johura Khatun were her parents, but her mother is still alive. OP are 4 brothers and 2 sisters. I do not know whether her father possessed Patta land or not. OP grandfather used to reside at Ujirer earlier. In the year 1966, OP's grandparents used to reside at village Pakhiura. I do not know when my father shifted from Ujirer Chor to Pakhiura. OP's father was elder than me. I do not know whether OP's father took birth. OP's brother and mother is now residing at Tinkonia Para. I do not know when OP's father used to reside at Darogar Alga.
So earlier, this DW2 stated that she took part at Darogar Alga.
Yes.
he stated that petitioner's parents are residing at Tinkoniapara.
Yes, Your Lordship.
And he also stated he doesn't know when his father used to reside at Darugaral.
Lordship,
Three statements you got.
Lordship.
Now, come to page number 52.
Lordship.
Kindly read.
I am working as secretary of Suryagiri Gao Panchayat since 3 years. Exhibit F is issued by me on 22/6/2015 in the name of Kamela Khatun, daughter of Saiful Ali of village Darogar Alga. A petition was filed by Kamela Khatun on 19/6/2015 for certificate. I have issued the same on the basis of voter ID card and on the recommendation of the president of Gao Panchayat. Through mistake, I have written the age of Kamela Khatun as 14 years in the certificate. It is not a fact that for whom I have issued the certificate and lady who is present is not the same person. It is not a fact that I have issued the certificate who not the-
Okay,
through influence.
Hmm.
Through influence. Actually, I have to retain the age of Kamela Khatun as 34 years, but I have retained the same through mistake as 14 years.
Now, from here you can see that an application was filed by the petitioner
Lordship.
on 19/6/2015.
Lordship.
The secretary who issued that certificate was serving in Suryagiri Gao Panchayat for 3 years.
Lordship.
And then on the basis of that application of the petitioner, he issued that certificate on the basis of the voter ID card and on the recommendation of the president of the Gram Panchayat. No record was considered because the cooperative society doesn't have the Gram Panchayat doesn't have any such record. It is not the statement of the particular secretary that on verification of records or whatever. Now, just see. As he took over charge only on 3 years back,
Lordship.
he is also not aware from records that the petitioner was residing in that area earlier. Either it has to be his own knowledge. He cannot have the knowledge because he became the secretary only 3 years back and she was not there. And definitely on the basis of the voter ID card and the recommendation of the president. Now, probably you do not have the, do you have a copy of that certificate with you?
No, I do not have Lordship. That is not a part of this. The LCR.
It's a part of the
LCR Lordship.
evidence.
Lordship.
Here, the secretary on 22nd of June 2015 issued that certificate saying that Kamela Khatun, daughter of Saiful Ali and Zohura Khatun of Darogar Alga,
Alga. Just born at Darbar, my lord.
village, and Sri Sujyogiri Gaon Panchayat under Matiar Avenue Circle of Gwalpara district, Assam, who is aged about 14 years, was a resident within the jurisdiction of the said Gaon Panchayat. Srimati Kamila Khatun got married on 1st of January 1997 to Sri Jilal Sheikh, son of Sri Motiur Rahman and Baharjan, who are residents of Buduchar village under Malta or Malpad Avenue Circle, Gwalpara district, Assam. Gwalpara district, Assam. Srimati Kamila Khatun has migrated from the said Gaon Panchayat area to the above mentioned location by virtue of her marriage, which is also solemnized as aforesaid. Now, this certificate issued by the secretary, though not on the basis of the records, even otherwise submitted, clarified, or whatever, that Kamila Khatun was of Darugar,
Yeah, Darbar.
and it was Sujyogiri Gaon Panchayat. Sri Sujyogiri Gaon Panchayat has issued that certificate. But you have also just read the evidence of the projected uncle of the petitioner,
Okay.
who clearly stated that when the parents of the petitioner resided at Darugar Agla, he doesn't know. You have read in the evidence of the DW2 at page 50.
Okay.
He doesn't know where she is residing.
Perhaps lordship, her uncle was stating about his parents,
Whose parents?
his own parents.
When
Your
OP's
lordship
father.
may just, if we
Who
want.
is OP?
OP is his niece.
So I do not know when OP's father used to reside at Darugar Agla. The previous sentence is that they are residing at Tinkoniapara.
I do not know when my father shifted from Ujjuri to Paksura.
That is with regard to his
His parents.
grandparents
No.
or his parents.
Lordship.
Then
Father used to reside
OP's
at
brother and mother
Lordship.
are now residing at Tinkoniapara.
Tinkuniapara.
I do not know when OP's father used to reside at Darugar Alga. Now come to page 49. Muhammad Hasmut Ali, aged about 52 years, profession business, son of Jinnat Ali, village Darugar Alga. And he doesn't know when his own brother and sister-in-law resided at Darugar Alga. Now, whose evidence is reliable?
Your lordship.
When this
Perhaps-
particular projected uncle have clearly stated, he doesn't know when the date state.
Perhaps your lordship, her uncle.
We cannot be in perhaps.
Lordship.
We have to be there
did
in
not
the,
know as to when they used to reside. Maybe
definitely.
of the time he was unsure of lordship.
He himself,
Lordship.
the question of time is not the issue. The case of the petitioner
Okay.
is that her parents, grandparents are there at Pakuria. There is no whisper that the grandparents of the petitioner at any time resided at Pakuria,
Pakhura.
at resident at Ujjayi, sir. It is only the DW2 for the first time deposed that his parents shifted from Uzirsar to Pakhira.
In the year 1966, OP's grandparents used to reside at village Pakiura. That is the,
Then.
I do not know
The
when my
previous
father.
sentence, the previous sentence,
OP had 4 brothers and 2 sisters. I do not know whether her father possessed patta land or not.
Hmm.
OP grandfather used to reside at Ujirer Chor earlier. In the year 1966, OP's grandparents used to reside at village Pakiura.
Hmm.
I do not know when my father shifted from Ujirer Chor to Pakiura.
Hmm.
OP's father was elder than me.
Hmm.
I do not know whether OP's father took birth. OP's brother and mother is now residing at Tinkoniapara. I do not know when OP's father used to reside at Darabaranta.
there is no statement that OP's parents is to reside at Darugar Alga. Now, if it is not there, how come the Gram Panchayat secretary could issue that he ceased to reside at Darugar Alga? You have produced that certificate to prove the link, is not it? So, how you have proved the link? Is it reliable? First of all, it is not on the basis of the record, it is only on the basis of the voter ID card. Whose voter ID card? Not exhibited. We do not know. Nor this Gram Panchayat secretary president adduce any evidence. It is not on the basis of the materials like the register maintained by the Gram Panchayat. Projected uncle clearly said the brother and the mother of the petitioner now reside in Koniapara. He doesn't know when OP's parent resided at Darugar Alga.
Your lordship may kindly consider the claim that the recommendation of the president was taken at the time of issuance of this.
Where?
certificate,
When?
Lordship, that Gao Panchayat secretary.
Who is DW?
DW3 lordship. He
Hmm.
reports that I have issued the same on the basis of voter ID card and on the recommendation of the president.
What
of
is the
Gao Panchayat.
recommendation? He is the secretary, he has the records.
Lordship.
Do you think these documents and materials are sufficient to prove the linkage between the petitioner and her projected father? Now show us where is the illegality in the order.
Only linkage was the certificate lordship, and that was not taken into consideration for
Why
the
it was
age
not taken into
discrepancy lordship.
Do you think, even if it is age
Lordship.
consideration,
Lordship.
that's 14 years, you have to read in total.
Lordship.
No.
But the Gao Panchayat secretary in his cross also he stated that it was mistake on his part.
That cannot be. You should have reissued. You should have cancelled it. That is the only ground for not taking consideration of the Gaon Panchayat secretary certificate,
Lordship.
right? And that is why the order of the tribunal is very low. Yes. Mr. Pine.
My lord, your lordship, like, see one thing, my lord, before going to the Panchayat certificates and etc. My lord, we have to see one thing, because as per the Sarbananda Sunal Para 26, my lord, before establishing the citizenship of a person, if he claims or she claims to lineage to a person as parents or grandparents, their citizenship has to be established. Now, in this case, what I have seen, my lord, the first of all, the citizenship of the
That's
Father
true.
itself
Only
is
in the
not-
1985 or 89.
yes, the father of the my lord, petitioner herself, father's citizenship is not established here in this case. Then only the question of lineage to the father will come, my lord. So, My lord, for that purpose, your lordship may kindly see, they have adduced voter list of 1966 and 1970. That is, my lord, is my lord.
Voter certified copy.
Yes, voter certified copy, 66 and 70. May examine 66 at page 16, my lord. This is of Pakhiura village. Suppose we accept that one Jannat Ali was there in Pakhiura village in 1966 and
As well as in
received
70.
as well as in 70. And we may also accept by that in 1979, though it is not certified copy, it was not exhibited. Though we accept that 1979 also, that same Jinnat Ali was there in Pakhiura village. So this Jinnat Ali and Deuta Nisa is a citizen of India. We have no doubt on that. And we are not casting any question on that. Now, my lord, the petitioner's father, whom the petitioner is claiming to be father, is producing the voter list of 1985 first time at page 24, my lord. The first time this Saifal Ali and this Johura Khatun's name appearing in the voter list of 1985 at the age of 31 and 23. Now, my lord, if your lordship, I have gone through, my lord, entire WS as well as evidence of all the persons, my lord, not only the DW 1, 2, 3. Nobody has said, my lord, when the grandfather died. When did the grandfather? There is no statement at all. What happened to the grandparents after 1979? Not a single statement. My lord, if the grandparents died, and this is of a different village, 85 voter list.
79 lordship, they shifted from Darogar Alga to Pakhiura to Darogar Alga.
Shifting, there is no statement in WS.
No, there is there.
No, this regarding shifting, there is no statement in WS. Only in evidence they have stated, my lord, this shifting part is coming. WS, your lordship will find.
WS, there is no shifting.
Yes, WS, there is no shifting. There is no mention of 1985 voter list. No mention, my lord. There is no mention of 1985 voter list also in WS. This is later on, my lord, after during the time of evidence, this 85 voter list is brought into and shifting is, my lord, stated.
Okay.
So, first of all, he has to establish this Safiar Ali of, my lord, this Darural Alga, whose name is appearing in the 1985 voter list and whom the petitioner is claiming to be the father, is the son of Jannat Ali of this, my lord, Pakhiura village. That has not been established. And that is more, my lord, that is not established. And that is more clear because the petitioner has intentionally, my submission will be very intentionally has not disclosed what happened to grandparents. Had grandparents been alive, my lord, there would have been a common voter list of the father and the grandfather. There is no common voter list, and there is no statement that grandfather died or grandmother died. So we cannot presume that grandfather and grandmother died, my lord. That presumption cannot be drawn by the tribunal without any evidence, my lord. So the Safiul Ali's presence in India prior to 1971 is not there. Existence of this Saiful Ali and Johura Khatun prior to 1971 is not established. So now, even though petitioner can establish somehow that she is the daughter of Saiful Ali, that will also not enough, my lord, to establish that the petitioner is a citizen.
Yes, then
So other discrepancies, whatever, my lord, as your lordship has already said, only the next, my lord, documents he brought is to link the petitioner himself to Saiful Ali. Even though, my lord, the Saiful Ali could not establish for the purpose of this case, my lord, if we examine the GP certificate also, it is clear from the GP certificate, my lord, the statement from the president, secretary of the Gaon Panchayat, that he had issued that certificate on the basis of voter ID card and on the recommendation of the president of GP. It's not on the basis of any record or any inquiry made by himself to that effect. So Rupjan Begum has clearly said this CC certificate, if we want to accept this as a proof of malad for shifting of a lady malad, then it has to be examined in two manners, malad. First of all, the authenticity of the document itself. Secondly, the authenticity of the contents of the documents. And second part, that is authenticity of the contents, have to be proved by the author of the document from the records. That is Rupjan Begum 2018 1 SCC 579.
what SCC?
2018, my lord. 2018 1 SCC 579. Para 16, 15, 16, not necessary. It's settled principle, my lord. The certificate, para 16 says the certificate issued by the GP secretary by no means a proof of citizenship. Such proof will come only if the link between the claimant and the legacy person who has been a citizen is established. But in fact, in this case, the legacy person whom the petitioner is claiming to be father, his citizenship is also not established. The certificate has to be verified at two stages. The first is the authenticity of the certificate itself, and the second is the authenticity of the contents thereof. The latter process of verification is bound to be an exhaustive process, in the course of which the source of information of the facts and all other details recorded in the certificate will be ascertained after giving an opportunity to the holder of the certificate. This is not done. This second part.
Okay.
So in absence of that, my lord, the evidence of DW3, the Panchayat secretary cannot be accepted, and the certificate cannot be accepted. Other discrepancies, whatever, as your lordship has already pointed out, that there are numbers of discrepancies with regard to this, my lord, address and residential address of the petitioner's fathers, etc. I'm not on that, my lord. Those are already in fact in record. Only my point is that father could not establish that he is a citizen of India. Then only if father could establish, then only my lord, the petitioner could say that being daughter of that person, I may also be treated as citizen of India. And apart from that, the certificate, which she is relying as my lord, the linkage certificate, that is not proof as per the law, though it is proof, my lord, certificate is proof, the contents is not proved by the GP secretary, and he has not given this statement or certificate on the basis of any record or contemporaneous record. So, furthermore, the tribunal has committed no error by giving that opinion, and other aspects, my lord, being certiorari jurisdiction, your lordship may not interfere the findings of the tribunal. Well, that's my humble submission. That's all.
Yes, reply.
Lordship, regarding her father's voter list, Lordship,
Hmm.
that that was never under challenge. No proceeding is initiated against her father regard questioning his citizenship, Lordship. He was regularly casting his vote. He's not there anymore, Lordship, because as DW2 has already stated, only her mother is alive. Otherwise, he would have deposed. So regarding that part, Lordship, as no proceeding was there against her father, and he was regularly casting his vote. So there was no question of his citizenship, Lordship. And regarding the credibility of DW3 Lordship, he is an independent witness, Lordship, Secretary of Top Panchayat. And the only mistake was that 14 years. He also deposed, and also in his cross he stated that it was his own mistake, Lordship, that he has put it as 14 in place of 34.
Hmm. And
Regarding her father's voter list, Lordship, her grandfather's name are reflected with her father, but
where?
as it is of as it no against his father's name, that is son of so and so. Your Lordship may kindly consider that in the year 1985, her parents were already married, and it is a general practice in villages, Lordship. After marriage, they shift to a close nearby village, Lordship. Her grandparents, they used to stay at Pakhiura, and thereafter her parents' name appears in the voters list of 1985 at village Darogar Alga.
Hmm.
That is all that I have to submit, Your Lordship. Her father's citizenship was never under challenge. That is
That
all,
we have not.
Lordship.
Okay. Administrator told us counsel for the petition.
M.R. Chaudhary, Lordship. M.R. Chaudhary.
You are Emma Chaudhary.
No.
Sorry. Emma Chaudhary, counsel appearing for the petition. Full name?
Mudabbir Rahman Chaudhary.
And Mr. J. Pine. Standing counsel home department exam for the restaurant number 2. 6. Mr. A.I. Ali standing counsel election commission for the restaurant number 3. And Mr. P. Sharma, additional senior government advocate Assam for the restaurant number 5. Noted. Your Lord,
Lordship, I have an unusual prayer. In item number 2, I had informed the court that I will file the wakalatnama during the course of the day, but due to some difficulties, we could not file it today. So I need some time. We will file it before the next day. Grateful.
Highly obliged, Lordship.
Yeah, please, your lordship. Lordship, I don't have the file, lordship. Some days may be allowed, lordship. I have to reconstruct the file, lordship.
Managing February. That's it. Thanks, sir.
yes, Mr.
Lordship, it may be taken up on after 1 week, Lordship. Due to some personal problem, Lordship. On 6th, Lordship. February. Obliged, Lordship. Morning.
On the prayer of MS Dev.
Or more detail.
List on 6th. Give us the.
More detail. Definitely.
মই জেৰক্স কৰি ল'ব পাৰিম।
More detail, maybe? Yes.
Registry shall reflect this matter, release this matter on thirty-eight, reflecting the name of Mr. R.K. Dev Chaudhary, Ghana Deputy Assistant at the Protectorate. Enabling him to place the relevant instruction that was sought for by the court on 22/08/2023. Mr. Sikdar, R.K. Dev Chaudhary was supposed to provide.
Yes,
us,
madam.
It will be listed on first. On 30. Next. Single that's very big. Second about commerce. Yes, Mr. Babu. You give us the date. Oh, when you are going to file the reply? Today is 25th. Bro. Yes, I don't forget. What? More than Mr. J. Hurmiya, counsel appearing for the petitioner. Prays for a short date enabling him to file reply to the affidavit of the PND department. Prayer allowed. The petitioner shall file his reply, such reply, on or before 2nd of February. Placed on 5th of February. Not 5th, 6th of February. Serial number 131 is a no, the affidavit that has been filed on you said Annexa 2. Who was the signatory? Who is the signatory of that document? Which part is not legible? Contents of the document. Bro, I could read you. Note it down from me. Sixth, yes. For 3 weeks on a date to be fixed by on behalf of Miss MSK Devi. An order, a prayer has been made on behalf of MSK Devi, leading counsel for the petition. Representative of the petition.
Micro facility.
Adjourn for 3 weeks. Date to be fixed. Where it has been listed for orders?
Review petitions, my lord, they come under the orders column. What are petitions?
What order was passed on earlier?
I will get to the later. I will do have
Yes.
the lordship's order at page 26 onwards. Of the review petition,
Yes.
page 26 onward, page 27, lordship would have. The first paragraph, my lord. Heard so-and-so learned counsel for the petitioner, heard so-and-so learned signing council, Assam Higher Secondary Education Council, assisted by so-and-so learned counsel for all the respondents number 1 to 3. But respondent number 1 was the Department of School Education, my lord. State councils could not be represented. Our representation was not there on that day. Now, lordship, if lordship kindly comes to the last paragraph from the bottom. After hearing the learned counsel for the parties and considering the entire aspect of the matter, the respondent is allowed to complete the process of selection to the post of junior assistant as advertised at the earliest on or before so and so, and to declare the result accordingly, thereby completing the said recruitment process in accordance with law if there is no other impediment in doing the same. Now, madam, the government had received several complaints regarding that particular recruitment process which was done. Lordship would like to have page 16 for a moment.
Hmm.
On page 16, my lord, there were complaints by the then invigilator of the examination, saying that months after the examination had taken place, people were approaching them with answer scripts and OMR sheets, asking them to sign the same, and thereafter those would have been inserted in the interview process. Thereafter, Lordship may kindly like to have page
So,
22.
So, Majunder,
My lord.
did you comply with the order passed in 4/10/2019, WPC number 286/2016?
410.
Or comply with the order dated? Not 4/10, it should be order dated 5/4/2001.
My lord, I was at item number 2, my lord. These are perhaps, yeah,
You are in a review petition, right?
item 2. Yes. I'm so sorry, my lord. I was arguing item number 3, my lord. I had the item number 3. I'm so sorry, my lord. Yes, I'm extremely sorry, my lord. I was referring to another record, my lord. I'm sorry. Well, fact is that, my lord, we are not denying the fact that we had not
Did you
complied.
comply?
My lord,
Did you comply as on date?
as on date. Yeah, if lordship gives me some time. my lord.
My lord,
I'll bring in
2016,
my
there is a order. Although I have challenged it, there is a compliance order.
Of which order?
WPC 286 of 16, order dated 4th of October 2019. My lord's order, against which they have come before this.
Whether the order dated 5/4/2001 passed in WPC number 1766 of 1999 has been complied with.
My lord, we have given our reasons, my lord. It has been complied.
Actually, against in the year 2016 rate petition, this order has been passed. Although there are some reference of 2005 or other things, but
Just a minute.
the copy I have, my lord.
It's a part of the rate petition 286.
Actually, it is against a series. The petitioner had to file 3 rate petitions in the year 2001.
That order which you are having in your hand
Yes,
was a part of the rate petition in 286.
yes. I am the rate petitioner.
Now, which order?
This order is passed by the Secretary to the Government of Assam
When?
on my lord 26th of June 2023. Although there was a time frame to
Ultimately, it was
pass a proper. After 3 years, they have passed. Date 2 after filing one. rate
It is a, whether it is a part of the rate petition,
Yes, yes.
annexer.
It would subsequently be said. It was passed subsequently.
After the order of this court.
Yes. My lord have passed the order of in the writ petition on 4th of April 2019. Thereafter, they have passed filed this review petition and I filed one contempt petition. Then only this order has been passed in the year 2023. Whereas my lord had directed to do the all things within a period of 6 months. And it states about the 2005 writ petition also.
এখন খালি উপর দিচ্ছেন এখানে আগে বুঝিয়েছে order to be there, it is 2026. Put more money for the example, not to put into speaking, you know, mean. When he will not kill me, the final order, not kill me. মানে media benefit, benefit দিয়ে না এখন কি হয় এখন বাকি ওরা কি করে থাকে তো পুরো যেগুলো টেস্ট করে মনে কন্টেন্ট লেভেল নোটিস দিছিল ভিতরে নিয়ে এসে দিচ্ছি ভেরিফিকেশন পেন্ডিং আছে কারণে আমি কন্টেন্ট একটু ড্রপ করে দেব আবার হচ্ছে এটা তোমাকে হেরি হয়ে গেছে আমি ওদের কাজ করি যেটা কন্টেন্ট নাই এখন কোন তার আগে কিছু এরপর মেন্টাল জীবন খবর আগে এখন লিখি এখন লিখি এখন এখন লিখে মুখ দিলে এখন তোমার রিপ্লাই এখন দিবে this is the last communication. Tell this one.
Now what happened after this?
My lord, in the order passed by your lordship, there were three directions. First of all,
Then what happened after this?
I have challenged it. Also, it is also not fully complied in conformity with the
That's a
order.
different issue.
I have filed one writ petition.
What happened there?
Notice has been issued.
Was there any stay?
No, my lord, not till date.
Are you aware of this step?
My lord, no.
Are you aware?
No, my lord, I have only. But only one factor is, my lord, we are not against the other part of the order. There was everything on merit, my lord, we are taking. If lordship will only have page 7, clause B, my lord. One of the
Page?
grounds, page 7 of my review petition,
Seven
ground-
of your review petition.
of the review petition, page 7, my lord. For that, so-and-so had filed writ petitions bearing number 1622, WPC number so-and-so 2003, 2004 relating to the upgradation of the post of assistant teacher and payment of salary, possibly due to pendency of the writ petitions filed by so-and-so earlier order passed in 176699 could not be complied with by the incumbents then holding the post at that time. And for non-compliance, the present commissioner method may not be held liable. Then lordship would like to have at page 8, paragraph C, my lord. For that, in compliance of Honorable Court's second order dated so-and-so in the case of the petitioner was duly processed in file number so-and-so 2005. From the note sheet, it appears that the file was frequently moved, so taking a decision from time to time with regard to claim the petitioner for appointment as LDA in Pamundi High School. During this period, reports had produced and serious anomalies with regard to selection and appointment of so-and-so were detected. The last noting on the file appears on 22/9/2010, wherein a letter was issued to so and so to come for hearing to be held on 28/9/2010. Thereafter, the process was kept on hold and decision could not be taken because of interim order dated 25/8/2010, passed in WPC 4714/2010, filed by Subodh Filter, directing to maintain a status quo. Paragraph D, my lord. For that the repetition number so and so was disposed of by order date 2616, directing him to submit representation to the official respondents ventilating his grievance. It is apparent that the department could not take any decision with regard to the claim of the petitioner Chandan Chandra Kolita till disposal of the repetition filed by Subodh Kolita, as the status quo order was operating in favor of Subodh Kolita. However, this fact could not be brought to the notice of the Honorable Court at the final hearing of the matter in spite of due diligence. For that the order dated so and so passed in WPC for taking a final decision with regard to the claim of petitioner for appointment as LD in Bamundi High School is now being fully complied with by passing a speaking order. Present incumbent who are holding the posts now were not working at the relevant time against the said person, therefore liability will not be fixed on them for the omission and delay in compliance. Therefore, may be pleased to exempt that exemplary cost of rupees 1,50,000. My lord, what had happened is, in the meantime, there were several petitions filed and there was also a status quo order operating for quite some time. The only prayer before this honorable court is costs, my lord, would come from the department. There is not a difficulty, but the incumbents, my lord, who have been saddled with the cost, my lord, they were not holding the posts at that point of time. And if lordship would kindly have paragraph A for a moment at page 7. 5/4/2001 order fallen from lordship, my lord. The review petitions humbly state that the first direction was passed in 5/4/2001 in WPC so and so dated so and so with direction to the director and inspector of school to examine the matter. It appears that a file bearing number EC so and so of 99 was opened in connection with the writ petition 1766 of 99, but it is not known why the earlier two incumbents holding the post in the year 2001 could not take any decision. But that file was open, it was under process at that level, my lord. It never came to the government level. Those we have with us,
Mr. Muzumdar,
my lord.
the statements that you have made,
My lord.
at page 7, para B, or at page
Yes, ma'am.
C.
Yes, my lord.
These are factual aspects.
Yes, ma'am.
Can it be a ground?
My lord, lordship had imposed
Then
the
what
cost.
was the reason why you have not filed affidavits earlier? Stating all these facts. What was the reason? You had an opportunity
Yes, ma'am.
in all the three petitions.
Yes, ma'am.
In none of these petitions, you have placed all these facts
But,
and bringing out a certain new facts now.
my lord, these are not, my lord, new facts, my lord, which I'm trying. which
Might have been in the
any
file
manner
that you
affected.
placed before the tribunal,
My
before
lord,
the court earlier.
my lord, I was not appearing in the matter that.
See, was the
I
council, was
understand,
the
I
officer who
understand,
are
Lord.
not concerned?
I-
They are
I-
considering as a department.
I understand.
In that case,
But therefore, my lord, the cost, my lord, if to be required to be paid by the department for not pursuing the matter properly is another matter, my lord. But incumbents, my lord, who are holding the post.
Let us assume that we pass an order, we reviewed the order, and we pass an order saying that the cost need not be paid. What will happen? What will happen?
My lord, the merits of the case will not be, my lord,
What will happen? Just tell me. Tell the court what will happen if we pass that order.
public money
That
to
part
some.
sensitive. Now, what you have done to save public money? Presently, these banks, not the single banks, the division banks are dealing with the matters of foreigners tribunal. Right?
Yes.
Will you be able to tell us how much money public exchequer? In fact, we have expressed it the last, yesterday or day before yesterday.
Yeah.
How much money you have spent for adult education? Will you be able to say?
Often.
Or how many years that particular scheme was there in force? How many persons who served on a contractual basis for a limited period in adult education, their services has been regularized?
Regularized. They have been regularized with the second
Right.
department. Yes.
Now,
And
what we have seen, all the female members of the families, particularly from the areas where these foreigners tribal matters are coming up. Oral can give only thumb impression, they cannot even write. But I can show you that for the same areas,
Adult
We have
education.
conducted those trainings. In fact, I also pointed out before the court. Who was there? Yesterday, just during last vacation, I have been to my village. My sister, who is a teacher, specifically told us, whether together discussing what is happening with her school. Female students from class 8, they will get married at class 8. By the time class 10 comes, they have to appear before the
Board.
test examination. They will become pregnant and they will drop out from the school. You cannot do anything. And she was surprised when she joined that school on her transfer. The class 8 girls, class 9 girls coming with Sindoor in the airport. They're shocked. She works in a particular school. Here are two types of communities are there. One is fishing community, another is religious minority. She also told us that if we do not feed the students of class 9 and 10, they will not come to school. They come to the school only for the food.
Here in Guwahati, around 4 days back, I had a fight with one of the serving people. They were planning the marriage of their daughter, and I had to threaten the husband. Somehow, if I can prove that this is underage, you are going in for something that I will be lodging an FIR. I had to stop it.
She told me when I particularly asked what is the reason. She said that parents, because
They can't-
they used to send the staff to the parents, house of the parents, the student. They used to come and say that they cannot have the children in their home because large number of children are there. The large number of children they have.
Children are.
So get rid of one daughter. Like, you have a daughter. Why don't you get rid of your daughter? Why?
Well, they are my
Why?
assets.
Why? That's the reason we want to know why.
They are my assets.
Right.
They are everything
So
I have in
things
the
are
world.
like this. That is why we ask the lawyers who are present before the court. So you are the people in society who can make a movement in this regard. Unless you make aware the people, your scheme will not help.
On my personal level, my
Look at
lord,
the independence movement, all lawyers, no engineers or nothing. All lawyers.
on personal level, my lord, I have been trying to get scholarships. I have been trying to arrange for whatever I can for girl child, anybody's girl child, for whoever wants to marry or for any
So
continue.
basically government, what
I
we
do
have
everything
seen,
I can, but my lord,
hoardings and these things will not move unless you go inside it. Because we know, we have the PLVs. We send the PLVs where you'll be very surprised.
Right.
There are villages till date where the government haven't reached. This paralegal villages for mere sum of rupees something. They used to go to all inside villages of Assam, not only Assam, in Nagaland or in Arunachal. Because no government job. And you'll be surprised to see how dedicated they are. But very happily working.
dedication
Things are
is something.
different. When you walk on both sides, you will realize that what is happening, what you are arguing, what you are placing for the government, what he is placing for the petition is totally different. Doesn't match at all. Will come, give lecture or make some road trip or whatever. Nothing happens. And that is the only the lawyers who can make a movement. And nobody else. Because still there is a faith in the lawyers in the villages. At least they will be able to give some relief to them. You attend some, anybody, you should attend from your locality when there is these kind of movements by legal services. Some of our judicial officers were secretaries of the district, working like anything. In fact, personally, I'm proud of those officers. Working day and night. There are certain lady officers, I'll not name them, but during the COVID period, taking that guts, everybody was inside the house. They were the people who were inside the villages. And I was surprised that we are not, at least I was not aware of those officers. Only when I start dealing with the legal service matters, then only I came to. At national level, our judicial officers, lady judicial officers won best award. In India, first topmost position. And definitely,
Hard work pays, hard work
and
pays.
that is the reason I am saying we have not seen, if you see these matters, how a person who doesn't know typing was selected, appointed as an LDA.
Work.
Then he was promoted when there was the direct recruitment for the teachers. There was no such consideration in the law at all.
And they-
The rule says you have promoted. How the officers of your department could have done that?
He is still serving.
Whoever is the authority, whoever is the minister's recommendation.
Wrong,
Even
wrong.
minister, how could a officer could have passed such a wrong promotion, illegal promotion? People are dying for government job. That person might have become a principal or headmaster by this time.
Well, there was a specific direction, but he is still serving. That is another issue.
They will not do.
There is no order regarding.
Basically, in that repetition, when that particular teacher,
No.
there was a move to put him down for the post of LDA when there was a stay. The government councils or the departmental councils, nobody said anything.
That is-
But the rule, it had been pointed out the rule, there is no specific provision for any promotion to the post of teacher from LD.
No, no, that, and in fact, there are judgments of this honorable court saying that
That
such
came
thing is
later,
wrong.
maybe from later. Let us assume that judgment was not there. But all the time, the recruitment rule was direct recruitment.
Yes.
When there is a case of direct recruitment, how come that could have been done there? How could have been promoted?
From what I have seen from the our discussions, Madam, that a promotion from grade 4 to grade 3, some try to,
10%. From
what they do is they try to say assistant teacher is grade 3, so the
even it
Madam,
is not
we
there.
had those discussions.
Teacher means teacher.
Things are
Question
now-
of whether it is grade 3 or this question is not that. You
Yeah.
cannot compare that.
Yeah, no, that is how they try to project things, Madam.
Nothing like that.
These have been stopped now, Lordship will not find, at least as of today, my lord.
Once there is an issue, they giving the benefit of the compassionate appointment, the N-harness scheme.
My lord.
The scheme was very specific. Grade 4 and grade 3. Grade 3, inside the grade 3, you will see LDA.
Yes.
Now, when the issue propped up before Justice V.K. Sharma as was then, in fact, he laughed in the open court. The government came with the approval that the teacher and LD are same, they are in grade 3. So teacher is in LDA.
Yes. That is what I was trying to
He
say.
said teacher is in LDA. Government said yes, grade 3.
Great. That is how
And
they,
that's why how it was extended to teachers. It was not meant for teachers, it was meant for LDA.
the compassion development scheme was, yes, yes.
It
That-
is in
that
the
is-
judgment.
That
It
is-
is in the judgment of Justice Sharma. His lordship has particularly mentioned it.
It is only perhaps because of the NCT norms that you need the DLED, BEd, everything that recruitment to the post of teacher stopped. Otherwise, this would have gone on.
So, Mr.
Anybody,
Mazumdar,
everybody could have come in.
when you are not complying your own orders, you could not place it before the court. Definitely,
Well, yes, my lord, at that point of time, my lord, there was no error in any manner. My lord,
so
in the
now
orders
removing
passed by the
this
government.
tag of 1,50,000, how will be benefited?
My lord,
Removing this 1,50,000 because you're representing the state,
my lord, the state, yes, my lord.
then
My lord, the officers didn't gun made mistakes, my lord.
no, see, then there is
Now
a
the
process.
government, my lord,
If there is a process for review
the lordship will only find,
of an order whereby not to recover this 1,50,000, then what you have done for reviewing your own thing and what you have done, the illegalities that you have done for doing the needful, still giving the benefit to whom who got the illegal benefit. Till that, this particular Subodh Kolita is getting that benefit. If you would have shown before the court that yes, you have taken action, maybe in the papers, will you be able to show that Subodh Kolita is no longer serving? Have you ever filed any review petition against that order?
That is correct, my lord.
Have you filed? Why you have not filed review against that order? Why you have preferred to file this review against this when there is a cost of 1,50,000? That is from public exchequer. And giving an illegal benefit to a teacher who has been illegally benefited as a teacher, that's not public exchequer. Ask the person who has advised you to file this review,
He is also retired.
right?
He is retired.
Why you have not filed a review in that writ petition? At any time, question of limitation is not there when an illegal benefit is given to somebody
It can be taken.
in violation of this statutory
Can be
rules.
taken.
Why you have not done? Tell us. Immediately we'll review this. It is not a case that somebody's got a benefit illegally. If he is doing illegal service for a long period, he should be considered to allow to continue that benefit. Is that the law? Court does not against anyone. Court only sticks to in the law, right? Then who is the commissioner, who is the secretary, who is the director? It's nothing. Who doesn't know anyone?
It is with the post of the message should go to the
And it cannot be.
whoever
just to
holds the
balance.
post.
You are allowing that man to serve, giving him salary.
Lordship gives me a day's time, my lord, I'll try to find out what has happened to that particular, I was not.
Go to tell us.
He is still doing my, as my.
Let find out. Question, you need to file that review either. It is not a question when a person has been illegally given that benefit.
Benefit it has to go.
That was the first thing, that review should have been filed here,
Correct.
not here. Even if it is a submission or admission of fact that the departmental councils did not brought it to the notice of the court. That's why he should continue. That cannot be in ground because the law itself, statutory rule provides that it is direct recruitment, question of thing. Even if we assume that there has to be promotion, how much? 10%?
No, the promotion from LDA to assistant teacher has been, my lord,
Cannot be.
barred by this court, my lord, barred by this honorable court. There
That is
no-
subsequent to that. Let us assume it is subsequent to that. By the time when that person was elevated or promoted from LDA, first of all, his appointment as an LDA was illegal. During that course of time, it has happened. You understood?
Although this order clearly says that his appointment was improper. That is there, my lord.
And response
So
number
good
5 appearance, that is different.
That's a good
We are
call.
not on that. We are presently on review anyway.
Well.
It's up to government. If you get that. If you get that. If you- If you-
Further, the government has decided not to take any steps to proceed the possible recruitment review in respect of upgradation of sewer filter. Post of demand. Further, the official record of paper is required, and as such, the requirement is to call for records obtained from the concerned office department. Records observed to be manipulated. In respect of the petition, to me, will be sent to forensic laboratory for identification. Identification নোহোৱাকে মোক কেনেকে cancel কৰিলে? মোক তোমাকে cancel কৰাই নাই, কৰিলে। সেইটোতো problem। সেইবিলাক সিহঁতে কৈছে যে inquiry কৰিব লাগিব, তাৰপিছত মোৰটো cancel কৰিব। তাৰপিছত কৰিলে এতিয়া কাম কৰিব। After examining verifying the records and express work will being upgraded the post of this department will fix the responsible disciplinary action against the erring officers. But he has not been terminated. No. Appointment of Subodh Kalita is pleasure with possession of
তাৰপিছত কাম কৰি আছে। তিনিটা ডাইৰেকশ্যনৰ এটাও কমপ্লিট হোৱা নাই।
More factor he's allowed to, he's continuing to work.
Still continue. Not properly designed. তাৰপিছত কৈছে যে আমি ভালকে কৰিব লাগিব যোন ৰেচপন্সিবিলিটি হয় সিহঁতক দিব লাগিব আৰু মোৰ কথা ক'লে যে মই ফৰেন্সিকত পঠাব কিন্তু ফৰেন্সিকত যদি পঠোৱাই নাই তেতিয়াহ'লে মোৰতো কিয় কেঞ্চেল কৰিছে তিনিটা ডাইৰেকশ্যন এটাও পুৰা প্ৰপাৰ কমপ্লেইন কিন্তু মোৰ হ'লে কেঞ্চেল কৰি দিয়ে
কিন্তু গুচাব পৰা নাই ন চবত তুলিছে
একো গুচাব পৰা নাই মোৰটোতো প্ৰপাৰ কনফাৰ্মেশ্যন দিয়াই নাই ফৰেন্সিকত পঠাম বুলিয়ে কৈছে ইনকুৱাৰী চলি আছে এতিয়া কিন্তু যেতিয়া মই চেক কৰিছিলোঁ মোৰতো বুলি যে কৈছে এইটোতো 2001 মই কৰা নাই
Yes, Mr. Muzumdar. Next date, tell us, which date, give us a date.
Lordship's convenience one.
No, no, you said 12th, 12th of February.
Correct. Straight copy बना के take this number, return it to him. Keep a copy of this. This is the one that I was referring to. Lordship's order at page 27. But here the respondent of the petitioners in the original writ petition prayed that the selection process for the post of junior assistants in the Assam Higher Secondary Education Council should be taken to its logical end by allowing the Viva Voce to go on and then finally declare the results. इनका फोन नंबर ले लो मुझको ले लिया इनका फोन नंबर ले लो यू रिटर्न इट नो ओके
Yes, the respondent number 1 was not heard.
Respondent number 1 was not my lord, and it is because of that, my lord. We perhaps could not bring on record the documents at annexure 1, page 16, which is a type copy of the complaints, my lord. The complaint lordship would find at page 20. Invigilators in that particular examination had written to us saying that they are bringing on the blank OMR sheets for us to sign, for them to sign. And my lord, even the then chairman of the council had written to the commissioner that, my lord, there were other anomalies also. Now, had this been brought to the notice of the honorable court, perhaps, my lord, the inquiry would have been allowed to be continued and brought to a logical end. But because of the absence of us placing these records, my lord, lordship had observed that the selection process be brought to a logical end. Now, my lord, the department presently, my lord, it's a very recent development. The department has found out that since we are now putting on the computers and everything, the requirement of the 49 number of posts as has been sought by the ESSEC is also not a reasonable demand, my lord, because the government has a control over the ESSEC to that extent, my lord. Recently, they have filed petitions.
The Commissioner Secretary, the Government of Assam, the Secondary Education Department. Respondent number 1. In WPC number 4859 of 2020. Disposed of on 04/02/2021. has filed this review petition stating that the said who was the respondent number one in the application number, stating that the said respondent was not heard. That no departmental counsel was present during the time of disposal of the said case. It is placed before the court that only the standing counsels of the respondent number 2 and 3 in said application number 4859/2020 as can be seen from the order of the court headed 0.1. After filing of this writ petition, notice was issued by order dated 02/03/2023, wherein the petitioner of WPC connected WPC number 4859/2020 is the respondent number 1. The respondent number 2 and 3 of said WPC number 4859 and present respondent number 2 and 3 in this review petition are same. The authorities in the Assam Higher Secondary Education Council from the office note dated 07/06/2023. It is seen that notice on respondent number 1 hearing registered for by the notice on respondent was served by registered for was duly served. As the copy of this review petition was served the address of the said respondent number 1 on 27/04/2023. Considering the notice on the respondent number 1 is found to be accordingly served, duly served. Registry shall reflect the name of standing counsel Assam Higher Secondary Education Council for the respondent numbers 2 and 3 in the qualification and shall list the matter on. Is on 12 we have fixed or 30?
12.
12, no?
12.
12.
12.
List the matter on. Put in the name of the standing counsel for an of the respondent list.
I'm obliged.
Sharma. Yeah. Broccoli. And taking it down. নর্মাল ফর্মে কত কিন্তু ইমেল করে দিতে পাঠাচ্ছে ঠিক আছে এটা আমার no representation on behalf of the petitioner. You're appearing for whom?
Lordship, PNRD Lordship, respondent number 1, 3, and 6, your Lordship.
What's your good name?
J. Bora Lordship.
MS. J. Bora, standing counsel PNR. That it. Question number 1, 2,
1, 3, and 6, Lordship.
1, 3, and 6. PN Thermal Comment. You are there, the education. What is it?
9, 9, we use 9.
You will also appear, since you're appearing for 6,
Lordship,
you will also appear for 5.
Lordship, but last occasion 2, 4, 5, 7, and 8, Lordship appeared J. Assam Lordship.
Comment. Registration in PNRD लिखते ना registry shall reflect the name of SC PNRD for the respondent numbers 1, 3, 1, 3, and 6.
6, Lordship.
Only 3.
1, 3, and 6, your Lordship.
And only for the respondent numbers 2, 4, 5, and 7 will be called list. List of the two weeks.
Obliged, your Lordship.
Now, this is a review petition and relating the matter relating to acquisition of land and land. The question was that my land was commercial, but it was when it was notified, it was said as agriculture. That is why I filed this writ petition before your lordship. However, I was directed to move before the arbitrator, and accordingly, I have filed a petition before the arbitrator. However, some my lord dates there are in the order. Dates
What is the order?
my lord, order is at page 10.
What review want?
Just my lord, at page number 12, paragraph number 1, 2, 3, the date,
21/06/21.
my lord, that date is actually I have annexed the annexer. The application was dated 13/10/2020. Although there was another application, but first application was 13/10/2020. If it is not corrected, there might be some delay related problem, my lord.
No, this, which line you are talking about? Page 12?
One third paragraph, the date is 20, the same to be agriculture, that therefore the petitioner on 29th of June 2021 approached the Kala for enhancement of the amount of compensation. It is correct, my lord. But this is not the first application actually. The first application was filed by me on 13th of October 2020. Because that day counts, my lord. Otherwise, if
What
this,
is that?
my lord, it is actually annexed in the repetition, my lord.
No, the petition is for us.
My lord, page number 15. Annexure 2. Thirteen 10/2020. This is the first application after the publication of notification. Against which one notice for holding an inquiry was also there, page 17. So that this first, this date, if possible, my lord, if it is not corrected, I may be some difficulty in the, before the arbitrator. There are another some points, my lord. The second paragraph, same page. Page 12, second paragraph, there is another, my lord, thing. 3 or 4 things, not more than that.
Yes. What is?
My lord, second order, review petition, page 12, second paragraph.
Hmm.
The one, fourth line, my lord. pursuant to the order dated, order of the Deputy Commissioner Golagat dated this, the Circle Officer Deregaon Heights order dated 2nd of August 2021 changed the class of the land. Actually, it was changed, my lord, in the year 1990. My lord may kindly peruse the page number 35 of the writ petition. And this is not an order. It was a communication given by the Circle Officer to the ADC. When I filed the objection, the ADC called for an inquiry from the Circle Officer, and Circle Officer informed this. And this is not an order, because order was passed in the year 1990, and accordingly correction was also made, my lord. I have the draft Sita copy. Correction was actually in 1990, but if it is not, my lord, corrected, there might be some problem. My lord, page number 14 of the review petition. The same thing, my lord, the commercial class land,
Okay.
it was changed. And my lord, page number 14, paragraph B, 2, sorry.
Which one? Page number 14 of the review petition?
Yes, yes, my lord, second paragraph, second line. Additional Commissioner, Upper Assam Division, Jorhat. It is actually called, I have instruction there, addition. It is called.
As per the certificate, it has to be additional.
No, addition means, exactly. Upper Assam Divisional Commissioner, not additional, my lord. Divisional Commissioner, come arbitrator at Jorhat. Upper Assam Divisional Commissioner, come arbitrator.
Upper Assam Divisional.
Divisional Commissioner, come arbitrator. Divisional Commissioner, come arbitrator at Jorhat.
For Assam Divisional.
Commissioner, come arbitrator. There is office, Upper Assam Divisional Commissioner, and at Kachari there is Lower Assam Divisional Commissioner.
Okay.
That is
So
another
page
thing,
12 two correction and page 13, page 14 one correction.
my lord.
Who is appearing for the National Highway? Any objection?
As of specs, no objection, Lordship. But as of today, no arbitrator is being appointed.
There is another.
As of today, there is no arbitrator.
No, actually, my lord, it was there.
It was
By
there.
virtue of the notification dated 13th of June, I think, 2023, that office was abolished. But prior to that, I have filed the petition. I have the receipt copy also. And after abolishing, I have been informed that there are to be another arbitrator.
Not appointed.
Till no-
Till now, not.
Since June 2023.
Where is that earlier arbitrator? He was,
My lord.
that post has been demolished, removed, and this new post has been created.
Oh, I had the notification, but I don't have the copy, my lord. I can provide you. But prior to that, I have submitted it.
Where is that copy? Let us.
My lord, I will provide you within that.
No, when
Within,
did you submit?
Submission.
at that time, that was there. And notice was also issued to the Deputy Commissioner and NHIDCL. There are other cases also by some different parties.
Give us that notification.
I will provide it, my lord.
In the second half,
Yes, before prior to.
give it to him.
Yes.
What's your good name?
C. Burwa, on behalf of Mr. C. Burwa.
Oh. Okay.
As my latest instruction, my lord, there was a writ petition for appointment of arbitrator and there was a direction and
We will not go to that. again.
yes.
Your lordship may take 7, my lord. The review petition, my lord, I will pray, my lord, your lordship may kindly dispose of the matter by clarifying the judgment. Because your judgment says, my lord, writ petition is not maintainable. But the judgment recorded the submission of the petitioner to the effect that the is a minority institution. Therefore, my lord, Provincial Election Act is not applicable. That is a wrong submission, my lord, because it is contrary to the affidavit filed by the petitioner. Your lordship will kindly see 72, because his service was provincialized in the year 2013. He did not get the fruits of it till date. It is because of the submissions of the petitioner, I think I'll
Respondent advocate.
respond in the book.
Yes.
The present review petition. That is at page 72. ma'am. The judgment is at page 72. There is no.
In the order dated 2nd of March 2016.
Yes.
100, page 111.
That is a WPC, my lord,
That's right. 70 review petition. That's what the order you want to
yes, 72, my lord, 72, 2021.
review.
Review petition 72.
Page 73.
Page 73, my lord, is the order.
There's a review petition, second review petition, talking about.
72.
I have filed item number 6, my lord.
And for item number 8, lordship.
Array, let one be over, but
Now,
73, my lord. My lord, your lordship will get 74 years. Mr. Sagar Learned Counsel appearing for the private respondent, present lead petitioner, present review petitioner, have also categorically stated that the Catholic Mission High School, Nagaur district being a minority education institution under Article 30 of the Constitution of India, as such, it does not come neither under the purview of the Assam Non-Government Education Institute Act 2006 and Assam Non-Government Educational Institute Regulation 2007, a rule framed under the said 2000 Act, nor under the purview of the Assam Venture Educational Institutions Provincialization of Services Act 2011. In this regard, Mr. Sagar Learned Counsel appearing for the respondent number 7 to 11 placed the provisions of section 2G of the 2006 Act as well as the provisions of section 1, subsection 1 and 6 of section 3 of 2011 Act. Mr. Sagar further submitted that the school in question, since does not come under the purview of the Assam Venture Educational Provincialization Act 2011, the state respondent cannot provincialize the service in question. Well, that is a wrong submission. Well, and contrary to the record of the affidavit filed by the petitioner. And the petitioners cannot claim any right for provincialization. The submissions of the Learned Counsel for the private respondent number so and so, Mr. R. Sagar, accordingly recorded. After hearing the parties and perusing the
educational institution.
Well,
Education
No,
department.
no, next paragraph you will listen. After hearing the parties and perusing the documents furnished by Mr. Sagar, the school in question is found to be a minority educational institution under Article 30 of the Constitution of India. And therefore, the court is of the considered opinion that this writ petition is not maintainable and accordingly stands disposed. So your lordship said, my lord, petition is not maintainable, but thereafter we filed a writ petition stating that, my lord, since the benefit of the provincialization order, your lordship will find it at page 19. Page 19.
Education and without a LPG. Education. No, without temper. Yes.
Yeah, page 19 is the order of provincialization. So your lordship has disposed of the matter saying that it is not maintainable, but in the process, Mala recorded the submission of the learned counsel for the petitioner, which is contrary to the affidavit filed by them. Page 19 is the order of provincialization. All persons they got benefit. Even other Catholic schools who are minority institutions, Mala, they also got benefit. Here the petitioner's name is at page serial number 118 and 119. Huh? 119. So this is the order of provincialization in the year 2013. Now the 2011 Act is gone. New Act has come. That the complication is there now. Your lordship may clarify, my lord, because we filed writ petition. Your lordship can you see, my lord, WPC page 79. We had to withdraw it because every time the submissions of the petitioner comes into, my lord, focus, my lord. Page 79, we filed writ petition. Your lordship will kindly page 81. Hearts Giyasuddin Ahmed, so and so minority institute, and they have provincialized in the year 2012-13. They have not been paid their salaries till date. The lordship has seen, my lord, page 81. Page 81. Miss R. Roy Chaudhary, Learned Standing Council, Elementary Education, submits that the petitioners herein were the private respondents in WPC 3393, which was dismissed by the order dated so and so. It is not dismissed, my lordship said not maintainable. In WPC so and so, the writ petitioners herein, who were the private respondents, had taken a stand that the minority schools in question did not come under the purview of the Provincialization Act. And as such, the state respondents could not provincialize the service. No, this is page 81. Because thereafter we filed a writ petition, my lord. In the writ petition, all these things have come into play. And main hindrance is the submission recorded on behalf of the present respondents and the present review petitioner. The writ petitioners have taken a contrary stand to the earlier writ petition. Further, it is not understood as to how the writ petitioners here could have taken a stand that there could not be any provincialization of teachers in the state schools at the time of disposal of the so and so, and have their services. Then, my lord, we had to withdraw the petition and come before this honorable court by filing a writ petition. That is at page 83. 85 is the order. Your lordship has allowed. And because of the submission, my lord, the affidavit filed by the present review petitioner is at page 42. That submission is not there. So therefore, my lord, I pray, my lord, your lordship may, subject to what your lordship may say, my lord, verify that there is no bar for provincialization because the matter is disposed of as not maintainable. since 2013, my lord, the order of proofs of the thing, my lord, could not be received. Otherwise, your lordship may remit the matter to the director. And the affidavit filed by the present review petitioner is at page 42. Nowhere, my lord, that statement is there. And it could not have been the statement of the respondents, my lord, who are the beneficiaries of the provincialization order, that Provincialization Act is not applicable. Wrongly, I think some record, some submission of this, has been made on behalf of the petitioners, my lord. So I pray, my lord, your lordship may clarify that and allow the petitioners to have the fruits of this order of provincialization. Otherwise, Provincialization Act, your lordship knows in minority that Dipankar Bhattacharya's case, 2003 GLP 480, my lord. Many minorities institutions have been provincialized by this state.
Mr. Das, please take your seat.
Yeah.
Yes, you are appearing for which petition? You are appearing for.
Your Lordship, I am appearing in petition, Lordship, item number 8, Lordship.
Review petition number.
No, it's item WPC, Lordship, item number 8, Lordship. That is read petition number 9822, Lordship. Here, your Lordship is directed to complete piece of Lordship.
What is your prayer?
Your Lordship, here, Lordship, on the last occasion, Lordship, your Lordship has directed to implead Lordship Bisoff Lordship as respondent number 9, Lordship. And accordingly, I have impleaded respondent number 9 as a Bisoff Lordship. And accordingly, the Bisoff set has filed affidavit in reply, Lordship, which will be, I think, at page number 107 of the office record, Lordship, in petition, Lordship. And paragraph number 7 of that reply, Lordship, they have clarified their stand, Lordship. They have no objection if the school has been provincialized, Lordship.
Who is appearing for the respondent, sir? 9.
Well, for respondent 9, I have appeared, madam, for the bishop.
Come this.
Well, I have filed also affidavit, madam, the lordship directed to file. Accordingly, emptied it and thereafter I file a Kalatnama and then file affidavit in opposition in her case.
Most of the provisions relating to the provincialization
Yes,
of the 2011 Act
lordship.
as well as the 2006. All are pertaining to the provincial act.
Lordship.
Now, to just read the provisions of let us go to now since 2017 Act is in force.
Lordship.
No longer is no longer in.
Right.
Read section 3.
Lordship. Yes, my lord. Eligibility criteria for selection of educational institution for provincialization of services of teachers, tutors. Subject to the provision of Article 30 of the Constitution of India, the following categories of venture education institution shall be eligible for being considered for provincialization of the services of their teachers and tutors. My lord, Roman 1, my lord.
That's what we want.
Lordship. The venture educational
No,
institution.
others also not written.
Lordship. So subject to the Article 30 of the Constitution of India, my lord. It was also, my lord, in earlier act also, my lord.
That is why we are asking you to read. Now read subsection 1, Roman 2.
Lordship. Subsection.
Same section,
Yes, Lordship.
Roman 2.
The Roman 2, my lord. The land, building and other infrastructure of such venture education institution in case of venture primary and upper primary schools shall, as far as practicable, at par with the provision under the Right of Children to Free and Compulsory Education Act 2009, Central Act 35 of 2009, and rules framed thereunder. Venture education institution in the case of venture secondary and higher secondary schools and junior colleges shall be, as far as practicable, at par with the provisions under Assam Non-Government Educational Institution Regulation and Management Act 2006, Assam Act of 4 of 2007, and rules framed thereunder. And in case of a degree college, same shall be as per norms set by University Grant Commission. Next, the
Others are
concerned.
not required.
Okay, yes, madam.
Section 4.
Venture education institution has a minimum total enrollment of 30 students
if it is a venture primary or upper primary school as on the date of coming into force of this act.
Section 5.
The venture educational institution has a minimum total enrollment of 25
Section 5.
Oh, sorry. Lordship. Land, building, etc. to vest with the government, with the effect from the date of provincialization of the service of the teachers and or tutors of the venture educational institution under this act, the land, building, and other asset of the concerned educational institution shall vest with the government.
Section 9.
Management of the educational institution where service of teachers are provincialized, with effect from the date of publication of the notification under subsection 1 of section 4, the administration, management, and control of all provincialized educational institution coming within the purview of this act shall vest with in the state government.
Section 10.
Managing committee in respect of primary, upper primary schools. The constitution, composition, powers, functions, and duties of the managing committee in respect of the primary and upper primary school shall be governed by the provision of the Right of Children to Free and Compulsory Education Act 2009 and the rules made thereunder.
Section 11.
Managing committee, governing body in respect of the other educational institution. The state government or officer authorized by the state government not below the rank of a district elementary education officer in case of elementary education schools, or the inspector of schools of the district in case of a high school, high madrasa, higher secondary school, by order passed in that behalf shall constitute a managing committee in respect of the high school, high madrasa, or higher secondary school, and a governing body in respect of senior secondary school.
Subsection
4. My lord. The state government or the officers authorized by the state government may reconstitute the managing committee or the governing body as the case may be, as may be required under the relevant statutory provisions.
Section 5. Subsection 5.
5. The composition of managing committee or governing body, as the case may be, shall be such as provided in the relevant act, rules, or orders, etc., in respect of the concerned educational institution.
6.
Subject to overall control and supervision of the director, all teachers and the tutor whose service are or would be provincialized under this act shall be accountable and remain subject to the control of the managing committee or the governing body as the case may be.
Now, not required further. Read. Come to the definition clause.
My lord.
Subsection P. 2P.
2P. (104) Yes, my lord. P.
2P.
Provincialization means taking over the liabilities for payment of salaries, including dearness allowances, medical allowances, and such other allowances to the teachers and or tutors as admissible to the government servant of similar category, and gratuity, pension, leave encashment, etc., as admissible under the existing rules to the government servants serving under the government of Assam.
Now also read 2K.
2K. My lord, governing body means the governing body of a college or a junior college approved by the appropriate authority as notified by the state government for carrying out the management of the college or the junior college as the case may be.
And 2M, managing committee.
Managing committee, man. Means the managing committee constituted under the provision of the Right of Children to Free and Compulsory Education Act 2009 or the rules made thereunder in the case of a primary or upper primary school, and in case of high school, high madrasa and higher secondary school, the managing committee approved by the appropriate authority as notified by the state government for carrying out the management of the concerned education institution.
Now, reading these provisions of the 2017 Act, most of which was earlier in 2011.
Lordship.
See, basically, the government
Okay.
decides to provincialize a particular educational institution or venture educational institution, except those who doesn't come under the purview of Article 30 of the
30.
Constitution. Article 30 of the Constitution is very clear.
Lordship.
If it is a minority institution,
Lordship.
administration, management, and control,
Lordship.
everything will be by the that particular community. Now, the government decides,
Lordship.
subject to Section 3(1), it has not to be, should not be a minority institution.
Lordship.
Now, let us assume the services of the teachers of this particular school has been provincialized. Now, once it is provincialized, whether it was under the 2011 Act or under 2017,
17.
because the 11 Act was
Already.
done, so it has become 2007. Everything goes. Management, administration, control, lies with the government.
Lordship.
Property lies with the government. The affidavit filed by the bishop,
Lordship.
you'll have no control over it. It cannot be tracked as any further.
Lordship.
If you read the judgment of the apex court pursuant to which 2-3 more judgments has been passed by our High Court,
Dipankar. etc.
you will see initially when the Provincialization Act of the
Yes,
high
sir.
schools came, when the first time it was challenged,
Lordship.
those educational institutions challenged because the management was taken over. The government imposed the
Yes, sir.
managing committee. And after such imposition, they challenged.
Yes.
The High Court dismissed those writ petitions. There's a bunch of writ petitions to various Hindi high schools.
Yes.
about us. Thereafter, the matter went to the apex court. Apex court, it was clear and definite. The affidavits were exchanged. Each and every Hindi high schools have categorically stated that even if
Yes.
the government withdraws or doesn't pay the salary, we'll be able to manage by ourselves.
Yes, sir.
But these are minority institutions. The Honorable Apex Court admitted the fact these Hindi high schools do managed by the Marwari communities or communities from Bihar, because there are schools in Chikya, Dibrugarh, various parts, Ujai, Guwahati, Dhubri.
Yes, one Hindi.
So
student was
in
there.
those cases, if you read the background, the entire fact, not the final judgment, the other judgments are also there. You will see it was directed to the government. Since they are paying the salary, the government,
Government.
they will continue to pay and take a fresh decision.
Yeah.
By that time, the government affidavit was that we have already started paying them salary, we have taken over. Subsequent to that, the Bengali High School, Guwahati, Shillong, those are reported in GLR, GLT, you will see. Following that judgment of the apex court, and directed for the Article 30 to what extent it will be able to have clarified in view of that judgment of the apex court. Now, provincialization is to be done under the 2017. Right? If that was a provincialization where the management was the rules in that particular law, that is why the management thing came. In that particular act, the property was not there. Property lied with the schools.
Yeah.
Only the management was, because the constitution of the managing committee was challenged by the government.
Yeah.
on the basis of which the Bengali High School judgment or the Shillong High School judgment. Right? But here in the 2017 Act, you have read these provisions. All property belongs to the government once it is provincialized. Whose provincialization? Provincialization of the teachers. What they will do on provincialization? They will pay the salary. They will give the other benefits like a regular appointee under the government.
Yeah.
And once they becomes not only the employees, it is not the case of the employees that they will get the salary from the government. Everything goes. The property will be belong to the government. The management will be the government. If you are ready, fine, we'll pass that order. Decision has to be whether you want to stick to each of the Catholic mission school under Article 30 of the Constitution of India, or you do not want. Because it is not the case of management alone here. It's a property because the act is very specific. Administration, management and control. It is not the management alone. It is that the government will continue to pay the salary after provincialization of teachers. It's not the case. Your affidavit shows you want to manage, you want to control, so that you'll be giving you your appointment. That was done in that particular act where the management was taken over. Now, if you want get to be provincialized, this particular school, you will only have the salary from the government. And you will be going on recruitment.
Subject to correction, my lord, when this earlier order was passed, my lord, that act was prevailing, my lord.
That order is no longer there, even if you read 2011 Act,
No,
same
sir.
provision. Administration, management, control will lie. That is why Article 30 of the Constitution. If any such minority school, right, linguistic minority, religious minority, whatever, which will come under the purview of the Article 30 of the Constitution, the objects such provincialization of the teachers serving in their school, managed by them, they will not be provincialized. But if it is accepted that some teachers have been, either you have to, after provincialization, you have to take out these teachers, put them in some other schools. There cannot be one part or two parts with the management of the school or the Catholic mission, and one part only with the payment of salary will be with the teacher of the government. That cannot be. The act is full. Administration, management and control. Now, as per the affidavit of this Catholic mission school,
Yes,
they
ma'am,
want the
that's-
management, they want the appointment,
Yes, ma'am.
they want the control. The
But
2017
my
Act,
lord, the appointment is subject to the my lord dot.
whatever, everything goes. The management goes, the property goes, the control over the school. That is why administration, management and control. These three things will be lying with the government once it is provincialized. That is why you have read the provision definition clause, what is provincialized.
Yes.
Provincialization means only the payment of salary to the teachers to be provincialized.
Right.
But the same very act,
Said my lord, otherwise. regarding
First,
part-
property will be of the government, section 5.
Right.
Section 7, management will be the government.
But whatever I understood, my lord, subject to the first section 3.
Ordered by the government, right?
Section 3, my lord, it says, my lord, subject to the Article 30, my lord.
Oh, yes. Subject to Article 30 means what? Article 30 provides that a linguistic minority or religious minority can establish any such educational institutions of their own.
Yes, my lord. And management also there, they can control, my
Absolutely.
lord.
Subject to Article 30 means if you object,
Yes, yeah.
fine. It will remain as a religious minority institution or linguistic minority institution. But once you were saying provincialization,
Yes,
you once provincialized. Provincialized means everything good.
my lord, in
My
this
lord,
regard,
may I just
I-
interfere?
my
This
senior,
thing
my
has
lord.
not come up.
See,
This
that is
question
the
did
reason-
not come up. It has not come up now, my lord. And only thing before this honorable court is 2009 13 provincialization order and 2017 act. Your lordship
Even if
has
it
read
is
it.
2013 provincialization order, it is on the 2011 Act. Even 2011 Act provides administration
That's all
management
right,
control by the government.
Provincialization order is there and your lordship has recorded a finding which has not been submission which is not the submissions of the.
They are not getting
petition.
the benefit of provincialization. That's what.
No,
In
but
her
the
repetition.
provincialization order, the order of provincialization is already there. They have not debarred anything, whether that management will not be there, building will be.
We are not
with the
saying that
government.
because of the affidavit filed by the Catholic
That-
Mission.
that
we are
is-
saying.
that is there.
You cannot have two things.
Because
Look at your affidavit,
what
what you
I
have said.
propose, my lord, ultimately, my lord, there are these two petitioners, my lord, whose services have been provincialized. They are not getting the benefit of the provincialization. And if anything is done by the
Provincialization means
government.
what? These two teachers will get the benefit.
Of
kind of
salaries.
salary from the government.
So it's from the
What will happen
government.
to the management and administration?
But this has not been, there is no separate order for that.
There is not required.
No, no,
Under which act they have been provincialized?
under the 2013 Act. my
So
lord.
if it is 2013 Act during its force, you read the 2013-11 Act?
No, but here what has happened, my lord, in your lordship's order, what
We'll
your
clarify.
lordship has recorded.
We will
Recorded.
clarify it. Doesn't matter.
That if your lordship clarifies goes, my lord, that is not my submission.
We'll clarify if you want because.
My lord,
Catholic
that is
Mission-
what I want. Rest of the matter, let government pass, my lord.
That definitely,
If-
because it is under Article.
If government passes some orders contrary or, my lord, and if the
647.
petitioner is agreed, so we'll come back again, my lord.
Yes,
Only
my lord.
that part of the order, if your lordship clarifies
You
that that
cannot
is
have
not the
two, Mr.
submissions
Das.
of
You
the.
have to have only one. If you want provincialization salary, it will go with
No,
that.
your lordship
That is the
only clarified
difference.
that order, my lord.
That is
Nothing-
the difference between the order passed by the apex court in the other Hindi
But
high schools.
I'm
and
not
state
going
courts.
there because this matter has not come up here. Well, that complication has not arisen here in this case, my lord. Only simple thing what I understand is that your lordship has recorded the submissions of the review petitioner, which is contrary to the affidavit filed by them. So therefore, your lordship may clarify that this is not the submissions of the petitioner, review petition. That will do because your lordship has not given any decision in the matter. Your lordship has only disposed of the matter saying that it is not maintainable. Only that much, my lord, because page 42 is the affidavit filed by us. Let government decide the matter.
Okay.
And if government passes some orders, even now, my lord, provincialization, whenever they provincialize, they have certain procedure, they follow it, and certain norms they follow it. We will have to follow the same norms. But this thing, my lord, this complication has not arisen now.
We'll take care of that. Mr.
My lord,
Das.
only that the affidavit filed by the present review petitioner is at page 42. We have not submitted that, my lord. Learned Council has submitted that. And that is, I think, is wrong on the part of the Learned Council. In
Yes, Mr. Yasuddin.
categorical,
Yes,
desperate
In
manner.
your affidavit,
Lordship.
Only that clarification, I think, my lord.
come to page
uh,
109.
109, yes, my lord.
That is will be your paragraph 4 at page,
108, my lord.
it starts at 108, that is 109.
Yes, my lord.
You read paragraph 4.
That before going to paragraph wise reply of the writ petition, the present deponent beg to state that he is now holding the post of chairman, bishop of the Diocese of Tezpur, which is situated at Bishop House at Tezpur in the district of Sunitpur, Assam, and earlier served as a member of Tezpur Diocese. The school, namely the Catholic Mission LP, ME, and High School, are under Tezpur Diocese and were established in the year 1963 and have been running in the same building situated in the same plot of land. The Diocese of Tezpur compositely under management of all three sections of his school, and this school is a minority education institution under provisions of Article 30 of the Constitution of India. The respondent number 8 of the writ petition is the principal secretary of the Catholic Mission ME School. The stand of the respondent number 8 that the minority education institution have the authority to control the overall administration and can take necessary steps for management and appointment of head of institution as well as other teaching and non-teaching staff, provided they possess requisite academic qualification as per norms is correct, and the deponent agreed as per remaining and mandate of Article 28, 29, and 30 of the Constitution of India.
Come to para 7 at 110.
That with regard to the statement made in paragraph 7, 8, 9, 10, 11, and 12, the present deponent, after going through the controversy and low points arise, out of the order passed in WPC number so and so, humbly submit that the government of Assam Education Department can provincialize the service of the teacher of the minority schools and have no objection as regard to the provincialization of teachers provided by school authority. There are many similarly situated schools in Assam. Those had been already provincialized time to time, but provincializations are done on the basis of recommendation of the managing committee of the minority schools. In this regard, the position of law already settled by Apex Court and also this honorable court reported in 2003 GLT 480 Dipankar Bhattacharya versus so.
So you want to maintain the management and control,
Lordship.
only the finance part salary of the teachers to be borne by the government.
My lord, as per Article 30, my lord.
Read Article 30.
Sorry, my lord.
Anyway, you have read the provincialization.
Lordship.
As
Yes,
per
sir.
the provincialization, section 5,
Lordship.
section 7,
Yes, I have go through.
then what?
So, my lord,
You cannot have one part from the government and the remaining would be you.
but so far earlier, my lord, that was done, my lord.
You are appearing for whom?
I am paying for item number, my lord, review petition 8522, my lord.
What is your prayer?
my lord? So I am the read petitioner, my lord, in this case, my lord. Because of these submissions, my lord, my case was considered to be non-maintainable, my lord. So when they have filed this.
Similar as that of Mr. Das's.
Yes, my lord, yes. So what I am submitting, my lord, since now the review petition has been filed, my lord, showing that it was not properly instructed, my lord. So he has submitted something beyond instruction, my lord. So I am praying, my lord, my writ petitions has to be considered because, my lord, apparently, my lord, on the oppositions that has been filed by the respondent there in my writ petition, my lord, it is admitted that, my lord, I am senior to them, my lord. I have been working since 1991, my lord. So persons below me, my lord, they have been, my lord, already been provincialized, my lord. Against that, we filed these writ petitions, my lord. But on merit, it was never been decided, my lord. So in any case, my lord, if the this review petition is being considered, my lord, and my lord, it has been open.
Your review petition is?
My review petition is 85, my lord.
No, your read petition?
My writ petition, this is my writ petition, my lord. This is 3393, my lord. This is page number, my lord. The same order, my lord, the under review, my lord, in both the case, my lord, 6 and 7, my lord.
Okay.
So I'm the writ petitioner, my lord, actually.
But only one aspect, my lord. They were appointed in 91 in ME school. And the review petitioner, respondent 8 and 9, they were from LP school. The LP school teachers were provincialized. And if there is a lot difficulties on that, my lord, the director can decide after hearing both the parties.
Yes, what about the government?
Item number 7. We have 5 because the 2011 Act. More of a lawsuit. Lordship, can you take up that affidavit file? I'm sorry, Lordship.
In a review petition?
In the review petition, Lordship, item number 7.
98.
72 of 2021, Lordship. Yes, affidavit pass.
Yes. Yes, we have seen.
Lordship, paragraph 5. The answer given the humbly stated that the petitioner claimed the writ petition being numbered so was to be provincialized. Service under the Assam 2011 Act. The answer given further expressed that the Honorable High Court that 2016 11 Act has already been struck down, Lordship. Paragraph 6, Lordship. Paragraph 6, Lordship. The answer given humbly stated that in the writ petition being number so and so, the present review petitioners was the respondent number review petitioner was respondent number 7 to 11, which was duly presented by their counsel and filed their affidavits in opposition and subsequently counter affidavit also. In their affidavit and also oral submission before this honorable court, they are vehemently objected regarding the provincialization service of the petitioners. Their contention in the affidavit was that Catholic mission schools are minority institute and they are run by the management of the school. Therefore, DO Nagaon is not appointing authority in the minority education institute. It is a school managing committee is the appointing authority. So they have already argued that matter. They have submitted before this honorable court. The answering deponent further
paragraph 7 states that the notification letter so and so is issued by the Commissioner Secretary of the Government of Assam, Secondary Execution Department on the basis of the Honorable Supreme Court judgment passed in so and so, which was clarified that Christian schools are run by the Catholic minorities in Assam, have the authority to take the necessary steps for their proper management, including their administrative matters, constitution of the managing committee, and the appointment of the teaching and non-teaching staffs. Therefore, even if the minority education institution is established and administered under the provisions of Article 30 of the Constitution of India, even though they are receiving aid from the government and the provincialized, do not lose the character of the minority education institutions. Paragraph 8, Lordship, the petition filed by the was dismissed on the submission as well as documents produced by the respondent of 7 to 11. And moreover, Lordship, your Lordship has pointed out that the provincialization, once the provincialization is given, Lordship, that management, administration, and control is taken over by the government. And even paragraph 10 also, Lordship.
Mr. Das, after the order of the court, passed in 3393, what happened? After the final order passed in 3393, what happened?
No,
So
Malad,
this was
then we filed a representation, Malad, we filed a representation,
Your service was already provincialized.
already provincialized.
How you
So
are,
therefore, Malad, I am not supposed to be affected, but they have affected because of the submission made by the
what
submission.
affected? Any first further order has been passed?
No order has been passed.
Then how you are affected?
Affected because they are not giving us, Malad, benefit of the provincialization,
Who?
the authorities, they are not giving,
The
so they.
petition was dismissed.
Hello?
The
No.
petition was not maintainable.
No, writ petition we filed, writ petition, it is
It is
recorded,
not you. You are not for the petitioners in that case. You are for the respondents only.
yes. But we
The
filed a
private
writ petition,
private respondents therein.
yes.
Was there any stay of the provincialization?
No.
Then
Nothing,
there was no provincial stay of the provincialization in that WPC number 3393.
my,
Now, after the order, when the petitioners of Ponti Borough and another was dismissed being not maintainable or closed
Right.
being not maintainable.
Yeah.
How have been affected? Any order has been passed against you?
there is no order passed because we filed a representation that has not been given, Malad, considered for the purpose of getting the benefit of provincialization. So we filed a writ petition here. And in that writ petition, my lord, it is recorded that my submission before the court. That was recorded, that your lordship has seen that page 79.
That the subsequent writ petition that you have filed?
Yes. And I had to withdraw because, my lord, I knew that, my lord, I have to file a review petition to get rid of the submissions recorded on behalf of the review petition. Is that at page 81? My lord, last paragraph, I'll read it again. The submission made by Mr. Roy Choudhury, Learned Standing Council, and the order dated so and so shows that the writ petitioners here have taken a contrary stand to the earlier writ petition. Further, it is not understood as to how the writ petitioners here could have taken a stand that there could not be any provincialization of teachers in the said schools at the time of disposal of the so and so, which was on 2/3/2016 and had their services provincialized as per the order dated so and so. reach the matter so and so, the next date, my lord, we withdrew the petition for the purpose of filing a review petition. Because I'm bound, my lord,
Was at any point of time your salary
salary has not been paid and I'm
by
unable-
whom?
by
Your
the
service was
director.
provincialized in 2013.
13, my lord, yes. Yes,
So-
the lordship has not interfered with the order of permission. Nobody has ordered.
Have you filed any petition challenging that action of the government?
That action has been challenged and that
What
is
was
the
the prayer
petition.
in the writ petition 2070?
2070. 2070. What's the petition copy? Or copy to a second, the prayer to copy a second. That page 81, your lordship will kindly see, they have
No,
not been
that's
paid.
true.
with the-
Where is that?
That
What was the
prayer.
prayer?
I'll get a copy of it.
You have withdrawn that writ petition for what
Yes.
reason?
Reason because my lord, court has recorded that I'm submitting that prayer for provincialization or benefit of provincialization contrary to my submissions in the writ petition disposed of in the year 2016. One of that page 81 is very clear. There also, my lord, I prayed for salaries
Record of
pursuant to the order of
WPC number 2070 of 2019. That was dismissed on withdrawal. On 12/02/2021. Withdrawal of the writ petition. Be called for. List on 20. We'll finally dispose of everything.
but it will be listed on
28th of February.
20th. Obliged.
In between, this court will be busy relating certain interview. So second half, there will not be possible. Oh, just a minute, not people, not people, not.
Thank you.
It is there.
Is there, my lord? I'll give you the petition copy. This is what the court is like. I say.
Mr. Gasuddin, just tell us one more thing.
Madam,
This Catholic Mission, LP, ME and high school are three different identities or one school?
madam, it is within the same campus, madam.
There are, see, if it is the same campus,
Yes, sir.
then it is in the other schools, provincialized schools, there is a merger, right?
Yes, sir.
LP is merged with the ME is merged with the high school.
Yes, sir.
Now here, what do we have to say? Whether these three are three different identities or one identity?
My lord, this point I cleared, my lord, in para 4 of my affidavit, my lord. Further. My lord, it was established in the year 1963 and have been running in the same building situated in the same plot of land. The Diocese of Tezpur compositely under management of all three sections of school. And this school is a minority education institution under the provision of Article 30 of the Constitution of India. That was my statement. Some document also in my affidavit, my lord. Lordship will find page.
Review petition 72 of 2021 in WPC 3393. With review petition 85 of 2022. In WPC number 3393 of 2013. Which WPC number 98 of 2021. Third, Mr. B.D. Das, Learned Senior Counsel, assisted by MS B. Deka, Ardeka, Learned Counsel for the review petitioners in WPC number 72 of the 2020. Third, Mr. Z. Alam, Current Counsel for the review petitioners in WPC number 80, in review petition number 85 of 2022. Third, MS G. Bora, right? Learned Counsel for the petitioners in WPC number 98/2022. Also heard Mr. Gyasuddin, Learned Counsel, representing the respondents in Catholic Mission LPME High School, Simona Bosti, Salna, District Nagaon.
And also impleted respondent number 9, man. In that litigation.
And also for the chairman, public bishop of diocese DIOCESE of Tezpur, the authorities concerned pertaining to the Catholic Mission LP and High Schools. It has to be Salna, Nagaon. That is under Tezpur diocese. But Mr. P. Sharma, right?
PN Sharma.
PM Sharma, Standing Council,
Elementary.
Elementary Education for the state respondent. Order is up.
Obligatory. Oh.
It up.
Item number 9.
What's the matter about?
Lordship, this review petition is filed for modification order by your Lordship. The two aspects, Lordship. When the court inquired whether the one office memorandum 16/2015 was applied in case of the petitioner when DLC rejected the case. But the instruction was placed and they said that yes, that was complied. But on the basis of that instruction, Lordship passed an order. After passing this order, I got the DLC, Lordship, but DLC, there is no mention about the compliance of this. This only they have marked that to be placed in next DLC, though where they specifically mentioned that due to vacancy or this or that reason, the case is not placed in this meeting, Lordship. Then subsequently, third time when it was placed, they said that the case is spent force, Lordship. Lordship, kindly see Lordship's order page 21.
Just a- Heard Mr. S. U. Ahmed, learned counsel appearing for the petitioner. This review petition has been filed. For review of the order
13/12/20.
dated 13/12/2022, passed by this court in WPC number 6809/2022, that was preferred by the review petitioner, the present review petitioner. In WPC number 6809/2022, Taravati. The case of the petitioner in say WPC number was that her father, please take your seat, Mr.
Yes.
Was serving as an assistant teacher at Rampur MB School. A provincial high school in the district of Lakhimpur. Father of the petitioner, Harendranath Gogoi. And he died. He expired on 19/04/2016 while in service. Who died before? Who died in harness? Only one. Thereafter, the petitioner applied within the relevant time before the District Elementary Education Officer Lakhimpur for consideration of her case to appoint on compassionate ground. Later, on 20/06/2016, she filed another representation before the Deputy Commissioner Lakhimpur informing the said authority that she had filed an application before the DU Lakhimpur for consideration of her case on compassionate ground of died harness scheme. That was forwarded by the said DU to the office of the Deputy Commissioner Lakhimpur. But her case was not placed before the district level committee Lakhimpur for consideration of such compassionate appointment with regard to her. As such, the petitioner in say WPC number 6809/2022, amongst others, prayed for a direction to the District Elementary Education Officer, Lakhimpur, Respondent number 5 daring to place the case of the petitioner. File a writ petition, thereafter the petitioner file the writ petition 680922 on 21/10/2022 for a redaction to place the case of the petitioner before the district level committee for compassionate appointment of Lakhimpur district in its next meeting. On 27/10/2022, the court directed the government advocate Assam appearing for the state respondents therein to place the relevant instructions in the matter, fixing the matter on 16/11/2020. On 16/11/2022, the government advocate appearing for district respondent therein, placing the relevant instructions in the matter stating that the case of the petitioner was placed before the district level committee for compassionate appointment of Lakhimpur district in its meetings held on 24/02/2017, 16/02/2018, and 04/07/2018. Though in those meetings, the case of the petitioner was placed before consideration before the DLC Lakhimpur, but due to non-availability of vacancy, her case could not be considered.
Lordship, may I point to one thing? Lordship, on the DLC it appears a vacancy is there, Lordship, but the specific reason is not mentioned. Only they said to be placed in the DLC, Lordship.
And in the meeting held on 04/07/2018, the said DLC, after considering her case for compassionate appointment on the date of her father on 19/04/2016, came to the conclusion that her claim for compassionate appointment has spent its force in terms of the government letter under number ABP.92/2012/32, dated 20/12/2012. The instruction that was placed before the court by the Deputy Commissioner Lakhimpur pertaining to the compassionate appointment of the petitioner was found incomplete, and accordingly, the Deputy Commissioner accordingly on 16/11/2022, the Deputy Commissioner Lakhimpur was directed to apprise the court and to place the procedure it followed since 01/06/2015 for consideration of appointment on compassionate ground. fixing the matter on 13/12/2020. On 13/12/2022, the Deputy Commissioner Lakhimpur by its communication dated 11/12/2022 placed a detailed report as to how it considered the case of the petitioner and considered the financial position of the petitioner as follows. Two numbers of family members after the date of the father of the applicant, comma. He is unmarried during the time of her application. And there was no dependent, no other dependent family members were employed. pertaining to the family status of the applicant. With regard to this family income status, monthly family pension was rupees 8599. Death cum retirement gratuity amount received was amount to rupees 5,41,434. General Provident Fund amount of rupees 2,10,000 was received. LIC insurance amounting to 4,25,12. Income from other sources amounting to rupees 25,000. Other service. Other services in 1, 2, 3, 4, 5, 6, 2. Other sources. Benefit of financial and altogether status of financial income amounting to rupees 12,10,145. The committee found that in the year 2016-17, the vacancy of upper primary teacher was 91 and lower primary teacher was 124 in grade 3. And 10 vacancies in a grade 4. As such, following 5% quota, upper primary teacher, 5 upper primary teacher posts were vacant and 7 posts of lower primary teacher and 1 post for grade 4. Considering the case of the petitioner, the committee DLC, in its meeting held on 24/02/2017, observed to place the case of the petitioner in its next meeting. Similarly, in its meeting held on 16/02/2018, the DLC considered the fact that during the year 2017-18, only 31 upper primary teachers fell vacant and 102 teachers for lower primary school fell vacant, whereas 6 posts fell vacant for the grade 4. As such, 2 numbers of lower primary teacher, 2 numbers for upper primary teacher, and 6 numbers of lower primary teachers were considered for compassionate appointment. And the case of the petitioners was again deferred due to non-availability of vacancy in its next DLC. On 04/07/2018, while the case of the petitioner was again considered. Was case of the petitioner only. The DLC Lakhimpur found 41 vacancies for assistant teachers and 6 vacancies for junior teachers and 70 vacancies for grade 4 post. And accordingly, the committee found 3 vacancies of assistant teachers and 1 vacancy, 3 vacancies for assistant teachers, 1 vacancy for junior assistant teachers, and 4 vacancies or grade 4 post for consideration under compassionate ground 5% quota diet and scheme. The DLC Lakhimpur, North Lakhimpur, in the said meeting on 04/07/2018, after consideration of the case of the petitioner, found that the claim of the petitioner span its course as per the government letter number ABP.92/2001 2/32 dated 2012. The contention of the petitioners before the course for review was that review on the ground that though there are vacancies for consideration to the case of the petitioner for our compassionate appointment, but the DLC Lakhimpur did not consider our case. The court, in the case of Achyut Chandra Das, or Dutasana, already. From the perusal of from the decision of this court in the case of Achyut Chandra Das, it is seen that court very specifically in their decisions provided as follows. Considering such decision of the court, pastoral indicators and the consideration of the district level committee for compassionate appointment, Lakhimpur, North Lakhimpur, in its meeting held on 24/02/2017, 16/02/2018, and 04/07/2018. The court, after reconsideration, did not find any valid reason for review of the order. It is 13/12 pastoral area connected to application number 609. Accordingly. So, in the order of matter.
Lordship. Lordship, when observed, see, 2 6 maybe Lordship mentioned Lordship, I have my submission Lordship. The order dated, OM dated is not considered by Lordship.
My lord, item number 10, my lord. This application, my lord, it is almost listed more than 10 times, my lord. I did not reach or council not.
You should have make a mention if you have urgency.
My lord, can it be on Monday, my lord? There is some urgency in this matter.
What kind of urgency you have?
My lord, since, my lord, this matter, disposed on 15/3/2023, my lord, thereafter, she's without having job, my lord, she's waiting for this orders review order, my lord. May I pay some early date, my lord, of this order?
You should have mentioned if you are in something urgency.
I waited to 10 will reach me, lord. I wanted reason, my lord. I waited, my lord. Set me, lord, short date, my lord. May I pray, my lord?
1st of February.
Deeply obliged, my lord.
10 নম্বর এটা এখানে না। Who is appearing for 11? Mr. Chauhan? Let it be also on 1st of February.
My lord, yes. Because my lord, lordship had to send 6 singles.